Welcome back to this week's edition of Freedom and Prosperity Radio, put together here at the Virginia Institute for Public Policy. You can find archived editions of this program by guest on our YouTube channel. Search Freedom and Prosperity Radio. Supreme Court nominee dominating the news even during the presidential debate. Amy Coney Barrett touring the Senate offices of whoever was still in town to meet with her. Kind of strange how that all worked, including Tim Kaine, who voted in favor of her appointment to the Seventh Circuit Court of Appeals, denied her any sort of visitation in her visits through the Senate chambers. Scott Cosenza, legal affairs editor at LibertyNation.com, author of The Bill of Rights and You, which I think should be taught in all the schools. But then again, that's just part of a long laundry list of things I think should be taught in school. Scott, how are you doing this week?
Well, thank you. Lots to chew on there for us, Joe.
My gosh. Well, first and foremost, I have to do this almost as a primer because this happens almost every time a Republican comes across having a Supreme Court nominee. The Supreme Court justices don't walk into a room with a legal billfold full of laws they want to tear up. That's not how it works. But yet again, here we go. Amy Coney Barrett's going to come in there and tear up Roe versus Wade, and it's her agenda, and that's not how the Supreme Court of the United States works, is it, Scott?
Absolutely not. The idea that Ms. Barrett, even if she wished to, could somehow engineer the death of the Roe v. Wade decision and its legacy is not true. It would take the cooperation of at least several other justices who evidenced no will to do so previously, Joe. Let's be clear. And it would also take a number of key cases to have worked themselves up through the courts to reach the Supreme Court, none of which Ms. Barrett would have control over.
Right. Yeah, there are too many variables there, but it makes for a good news copy, I guess, or at least it gets your website click-throughs.
You get to play the game if the politician on the screen is either ignorant or disingenuous. You know, it's a fun game to play.
Yes, unfortunately, we all sit there and lose in that game. That's it. So, take us into her judicial career, and she's certainly had her time on the Seventh Circuit, and that was her, I guess, selling point over any other candidates. She had a record to run on there. So give the listener a little better feel for what Amy Coney Barrett's career has been like to this point.
Sure. Well, in terms of the actual judging, let's say, I don't think there's anything for us to look at on abortion or other issues that we can glean, a forward-looking outlook, except for one, which is guns. Mm-hmm. She did make a dissent on a ruling, and that ruling said that a person who had been convicted of mail fraud was able to be denied their Second Amendment rights. And Judge Barrett dissented from a panel ruling, and she said that the prohibition on maintaining gun rights after a person has served any time has to do with their potential for violence. And there is none here, basically, because of the mail fraud conviction, and therefore these rights shouldn't have been swept away. So I think that's a very positive decision, not just on gun rights, Joe, but for all rights, meaning she's looking to maximize the rights of the individual and minimize the rights that the state can take away.
Well, and certainly putting it back in the lap of a legislator that might conflate this, a mail fraud with a bank robbery, and not all felonies are created equal.
Well, especially we're 3 felonies a day. I forget who wrote the book, but it's a great one. We're all in a world where we don't even know what the criminal laws are necessarily, much less be able to follow them all.
Harvey Silverglate, who's been on this program as well, great, it's a terrific book, and chilling, really, if you think about it.
It is.
When you look at her career, and I guess this is the hardest thing, is a good justice can't necessarily be pigeonholed by precedential opinions because each case, and now I'm trying to remember, I think it was Scalia was the one who pointed to the fact that every single case is full of nuance and differences, and that he wants to judge each case as it comes, not just make some sort of blanket rule that if it's about this, I'm going to rule this way. And I find that refreshing in any justice, whether they be local Charlottesville Circuit Court or on up.
That it is refreshing for you and I. I think that the other universe of people, though, is shrinking who find that refreshing. And I think part of the reason on the right, Joe, is that they've been disappointed by so many previous picks who they thought were going to be of a like mind with them on so many decisions. And then we have Roberts, who's continuing to disappoint, and Souter, who, of course, was the momentous disappointment on the right.
Mm-hmm.
And so on the left, that's who they seem to pick more. These people who are fellow travelers, and they're going to be able to kind of predict what they get from them. I think that for Ms. Barrett, just getting back to her career for a second, so we only have a brief window with her judicial career. Basically, she was a law professor for her whole career until she entered the judicial service recently. And so I think we don't really have much to go on until her law students start talking about her, which I'm sure we'll get some in the hearings. We'll probably have some surprises. And I feel like I just rambled on there.
Well, no. It's important to point out, but she has clerked at the court. She clerked for Justice Scalia, and then she went on to her legal career and to her work. And people are trying to make out that she's going to do this or that. I find one of the most humorous parts of this, and Ted Cruz started it, and Chuck Schumer has picked it up as well. They're referring to this as a 4-4 court right now, as opposed to the 5-3 if you judge by who was appointed
right.
by what president. But I guess we've traded John Roberts for a first-round draft pick along that line. What are
one thing, Joe? Let me just add this one data point I came across, and I hadn't heard many people talk about it. I think it's fascinating. Maybe we'll see if it's too inside baseball or not. But every single justice on the Supreme Court, if we can include Ruth Bader Ginsburg too, has a degree from Harvard or Yale or both.
Wow.
And in Trump's dozen women that he said he would choose this justice from, only one of them had a degree from one of those schools. And it wasn't Amy Coney Barrett. So there is I think a movement away from that Northeastern establishment sort of legal club, which I think also has ramifications for how the court's going to rule.
Is there more to that than political ideology? Is you're a creature of the system you've grown up in almost as much as you're a creature of any political ideology, Scott?
It's if you're highly motivated politically and you're a high achiever, that's where you gravitate to. Ben Stein actually wrote an essay about why he went to Yale Law School and why Hillary went to Yale Law School as well. And I think that's instructive. And it's basically, if that's your bailiwick and you excel, you just naturally want to go there. It's like playing for the Yankees, I guess.
Well, Scott Cosenza is on with us, legal affairs editor at LibertyNation.com, policy director at OneGen, author of the Bill of Rights and You. Scott, so what is we hear a lot of, obviously November 10th, the Supreme Court is going to hear arguments on the constitutionality of what remains of the Affordable Care Act without the individual mandate there. What else notably is on the docket that Justice Barrett, should she be confirmed, will join the other justices in hearing out?
Well, I think I'm a little preoccupied with guns as a policy issue, Joe, so
True.
Maybe this is wishful thinking, but I think that we are going to see a major gun case, and the reason why is because one of the things that motivates the Supreme Court to take cases when there are what we call splits in the circuits. So if there's a different ruling in one geographic circuit than another, that seems to be an untenable solution for the country. We have a number of jurisdictions with wildly different rules about gun regulation in the country in the wake of the Heller decision. We're still sort of putting the pieces together from that. And we have a couple of Supreme Court justices, Joe, who have criticized the court's lack of taking these cases. Justice Clarence Thomas has written about it. I think Gorsuch has spoken about it. And so I think they want to take a gun case to clarify the rules. I think they need to. And I think they will now with Ms. Coney Barrett, because if she's confirmed, I think that her taste for that case will be much different than Justice Ginsburg's would be.
Well, you mentioned Heller, and Heller is the case that actually establishes what the Second Amendment means when it says to a well-regulated militia is not the Second Amendment isn't there to create the well-regulated militia. It is there to give the citizens the ability to regulate the militia. And so I think this year, amongst all the other things 2020 is going to be remembered for, is the fact that the civilian population of the United States can cause quite a ruckus if given its opportunity, and perhaps why the Second Amendment was there. What more do you think they want to do with that ruling in terms of clarifying it or straightening it out?
By the way, the whole question of what happens to gun politics in the wake of the COVID shutdown and the reaction to it, that's a fascinating question by itself. We don't even yet know what those numbers are going to look like. I think we're going to see a lot of movement towards the pro-gun side as people have realized, they do need to be independent for their security. It's the legacy of Heller, Joe, in the form of the McDonald opinion. So Heller says the Second Amendment protects an individual right to keep and bear arms. That's the bold print ruling. And then the McDonald case says this applies to the states, and it's incorporating the Second Amendment, which hadn't been done, against the states. And so now it's a fight about, well, what does that mean? Am I allowed to carry a gun outside my home? Is that part of my fundamental right that's protected under the Second Amendment, recognized by the Constitution now? Can a city stop me from walking in a park with the gun? Can they, require trigger locks or other things? Are these legal under that restriction? And that all has to be worked out. I think the carry issue is probably the number one thing that gun owners, want to see happen, which is a right to carry that is constitutionally protected, because of all the various politicians who try to frustrate that right in various places.
What is, and I'm going to confess, and I can't remember if it's 14 or 70, which is the amendment that mandates that if something is in the Constitution, that a state can't say, well, we're going to ignore that because we have states' rights. I know it's in the teens.
The 10th Amendment. I think.
Well, the 10th Amendment gives states, their individual rights. But there's a following amendment written after the Civil War that said the states can't violate the Constitution in their individuality, though.
You mean the Privileges and Immunities Clause in the 14th Amendment?
That's I knew it was either 14th or 17th, but yeah. So
by the way, they're often combined when judges write these rulings too. Yeah. They'll often find reason in both to hold a law as valid or invalid.
Well, yeah, and I want to be known as rare amongst talk show hosts, somebody who will actually admit he didn't know something and ask the guest for the information. But wouldn't that imply that if something's in the Second Amendment and this is what the Second Amendment is ruled to be, then the states can't violate it? That's been the argument in Virginia. A lot of cases where cities are creating extra curricular restrictions on gun carrying in public places, near public buildings and places where they may seem to have some sway.
Joe, incorporation is kind of a weird area of the law because it's not written down. It's judge-made law. The justices of the Supreme Court decided to incorporate the protections that the Constitution gives people against federal government action, against state government action. They kind of invented it, and we've just sort of run with it, and they've gone little by little through the Bill of Rights, incorporating these various protections against states that we have against the federal government. So this protection or incorporation of the Second Amendment right is new. I mean, the right itself, as recognized, was new with Heller, and then after Heller is when the McDonald decision came that didn't make the incorporation happen. So that's part of the reason why there's so much action in the courts and why it's been so kind of really surprising that we haven't seen Supreme Court action on any of these cases.
Scott Cosenza, Legal Affairs Editor, Liberty Nation. We're talking about the Barrett nomination in abstract in some cases, but one of the things that it seems to bring to the fore is that most of the Democratic Party membership and a decent amount of the Republican Party membership in elected office seem quite comfortable with the idea of legislating from the bench. They would rather John Roberts decide Obamacare than them come up with something else, or gun laws or anything like that. So, failing a legislative Roe v. Wade vote up and down, they don't want that, so they'll just leave it to the Supreme Court to make these decisions. Is that ever going to change in your mind?
When the public demands that it does, Joe, I think is the answer. I too have heard more than one politician on either side of the aisle say, well, basically we'll leave it to the courts to decide the constitutionality of it, and that's absolutely wrong. No matter what your political persuasion is, every person that swears to uphold the Constitution and has anything to do with the lawmaking or governing process needs to make sure that it's checked each and every step of the way.
Well, I know that listeners frequently will, address some law that's passed, and how do they get away with passing something so unconstitutional? I say, well, It's not like the Supreme Court sits in the room like an editorial board and gets every bill before it's passed. You say, no, you can't do that one. We wish, I guess, in some cases, but this is the process. Is somebody has to suffer under an unconstitutional law and then bring it to the court.
And also, a journey of 1,000 miles begins with a single step. So it's that first path down, straying from the Constitution that leads us to these. You turn back and look, and oh my God, look how far we've come. I think that's another way to look at it as well.
Well, and certainly here in Charlottesville, we know Buck versus Bell, and that wasn't even a good Supreme Court ruling where the court ruled in favor of the state's right to order somebody to be sterilized. So, the court gets it wrong sometimes as well, Scott. So back to Amy Coney Barrett, though. The politicization of her nomination is probably going to lead to a 52-48 vote in the Senate, and okay, she passes, but, gone are the days, it seems, Clarence Thomas was almost an outlier for the vehemence that was seen in his opposition. Ruth Bader Ginsburg, 97 votes in favor of. Will we ever get back to a place where a Supreme Court justice nominee can actually get a reasonable high percentage of both party support?
I'd really like to see that, Joe, but I'm not terribly encouraged. Judge Bork, I think it all goes back. We can loop it right back around to Roe v. Wade and abortion, because that seems where it all comes from, the energy behind this. When Ronald Reagan nominated Judge Bork to be a Supreme Court justice, he was a mild-mannered Yale Law School dean who had served for some years on the D.C. Circuit Court of Appeals without any kind of ruckus or controversy, okay? But the left thought that he would be a vote to overturn Roe. And so not even an hour after his nomination was submitted, Ted Kennedy went on the floor of the U.S. Senate and basically made him out to be like a neo-prohibitionist, anti-woman
that speech is famous.
Monster, okay, like a monster. And all of the facts were not true. He just lied about Judge Bork, and I think it was just about abortion. But here's the kicker. The few years prior, when Judge Bork was nominated to sit on the D.C. Circuit Court of Appeals, the highest appellate court in the land, he was unanimously approved by the Senate, including by Senator Kennedy.
Yes.
So it's like approving somebody to be the vice president but not the president. It kind of doesn't make any sense. And he didn't seem to have to pay a price for his hypocrisy in that regard. And so the most recent kind of talk I've heard about this sort of thing is that the Democrats at least could say, hey, look, if we get back into power, we promise we're going to start adding protections for the minority. And we understand maybe you can't do that for us now because we stripped them, but we'll act in advance. But we have the exact opposite. You mentioned at the start of our conversation about the court packing talk.
Yeah.
And that seems to be more popular with those spokespersons on that side than sort of a de-escalation. So once again, sadly not encouraged. What I don't hear anybody asking to any of the court packing people is, why wouldn't then the next the other party, when they get into power, simply add more justices? And how does that wind up to accrue to a better outcome for the American people?
I believe I may have heard one liberal commentator bring that up, and I haven't heard from them again. So they must have, fallen astray of
Right.
the 200 million Joe McCarthys that are out there on social media, Scott.
Oh.
So is it going to be a 50, or would a Tim Kaine, who saw something in Amy Coney Barrett to approve her for the 7th, break party ranks and maybe say this is a bridge too far, or a Joe Manchin again?
You're talking about Hillary Clinton's right-hand man there, Tim Kaine. I can't imagine that person. I mean, I'm less of a political analyst than I am a legal analyst, but I just can't imagine him breaking ranks unless he thought that his future, and call me a cynic, his future electoral prospects were to suffer. So I would say senators that are up for re-election or will soon be, with heavily Catholic, swing state kind of jurisdictions, that's where if there are any votes to come from the Democrats, I think they will come.
During the debate, I thought the president was remarkable in his rebuke of the vice president's call for waiting until the voters have had their say. And he spoke very bluntly. The voters did have a say. They elected me. I'm a president, and quoted Ruth Bader Ginsburg on the subject. Have we decided now that just because we don't like somebody, they don't get to serve their full term in office? Is there some sort of shadow impeachment I'm not aware of?
It would be helpful if the media were able to help separate what is clearly political bluster from an actual, some sort of charge of malfeasance, and the politicians aren't doing any help by muddying the waters in that regard. The president is the president for 4 yethat and that term runs from January to January. It doesn't stop in November. One thing I think they missed a line for, not that I'm taking sides, but the Obama and Biden, they were willing to serve right up until their very last day, monitoring the efforts to monitor the Trump administration incoming. Right,
that's right.
They didn't give up their wiretap monitoring as they were walking out the door. They stayed to the very last day, and so it makes sense that Donald Trump would use his power until he has none more to use.
Well, I appreciate your time. Scott Cosenza, legal affairs editor, LibertyNation.com. Thank you for your insight on the president's Supreme Court nominee and the nomination process and where we go from here. And we'll talk to you again very soon.
Joe, thank you for getting the word out and advancing freedom in our time. I appreciate it.
Well, and for all of us here at the Virginia Institute for Public Policy, that's how we roll. My name is Joe Thomas. Until next weekend, so long, and thanks for all the fish.